Hello everyone. We welcome you all to our second series of Laws on Company Law, a byproduct of our YouTube channel, The Noble Litigators. Today, I'm Advocate Upasna, Legal Associate at the Law Offices of Kumar Vivek Advocate and Associates, is going to discuss about the powers, liabilities and duties of directors. So first of all, powers of directors. The Board of Directors gets its powers from the Articles of Association, Memorandum, and provisions of the Companies Act 2013. And some of the powers are as follows. So, first of all, general powers of directors. Section 179 says that the Board of Directors of a company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to exercise, but subject to the provisions contained in the Act or in Memorandum or Articles of Association. Now, the second is collective powers of the board. The collective powers of the directors are to make calls on shareholders in respect of money unpaid on their shares, to issue securities, including debentures, whether in or outside India, to borrow monies, to invest the funds of the company, to grant loans or give guarantee or provide securities in respect of loans, to approve financial statement and the board's report, to diversify the business of the company, to approve amalgamation, merger or reconstruction, to take over a company or acquire a controlling or substantial stake in another company, or any other matter which may be prescribed. And the aforementioned power shall not be deemed to be affect the right of the company in general meeting to impose restrictions and conditions if the directors are acting malafide or against the interest of the company. If the board is interested in a transaction, so they shall be incompetent to work, and if there is a complete deadlock in the management. So the third power is power of boards to be exercised in general meeting. Certain powers can be exercised by a board with sanction in a meeting of shareholders only, namely to sell, lease, or otherwise dispose of the whole or substantially the whole of the undertaking of the company, to invest otherwise in trust securities the amount of compensation received by it as a result of any merger or amalgamation, to remit or give time for the repayment of any debt due from a debtor. So the fourth is managerial powers of directors. The directors are the limbs of the company, so they have all the powers for better and effective management of the company, including power to enter into contractual relationship for the mobilization of stock in trade, power to declare dividend, power to allot, forfeit and transfer of shares, power to appoint director to fill up casual vacancies, power to issue debentures or hybrid instruments, power to appoint managing director, manager or secretary of the company, power to formulate and execute policies related with corporate affairs of the company, power of control and supervision of other personnel in the company. Now comes to the liabilities of the directors. So first is liabilities against the company. The director will be liable. The directors will have to make good loss for any The directors will have to make good for any loss on account of an ultra vires act where the directors have entered into a contract beyond their powers. Breach of trust where the directors make a secret profit out of the business. For negligence or for not performing his duties honestly and carefully. For dishonest act to make personal profits. For the activity of the co-directors. Second is liability towards third parties. The directors will be personally liable towards the third parties for any misstatement in the prospectus, for the failure to repay application money on a non-receipt of money minimum subscription, failure to repay application money on refusal to list share by the stock exchange, for acting in their own name without mentioning the name of the company, for acting beyond the powers of the company when the liability has been made unlimited by the memorandum, and for any liability at the company at the time of winding up. Now the third is the directors will be criminally liable for the misstatement in prospectus, failure to file written on allotment with the registrar, failure to give notice to the registrar for conversion of shares into stock, failure to issue share certificate and debenture certificate, failure to maintain register of the members and register of debenture holders, default in holding annual general meeting, failure to provide annual accounts and balance sheet, for holding the officer of the director in more than 20 companies. Now comes to the duties of directors. A director of a company shall act in accordance with the articles of the company. He shall act in good faith in order to promote the objects of the company for the benefit of its members as a whole or in best interest of the company, its employees, shareholders, the community and for the protection of environment. A director of a company shall exercise his duties with due and reasonable care, skill and diligence. A director of a company shall not achieve or attempt to achieve any undue gain or advantage either to himself or to his relatives, partners, or associates. A director of a company shall not assign to his office and any assignment so made shall be void. If a director of a company contravenes the provision of this section, such director shall be punishable with fine which shall not be less than 1 lakh rupees but which may extend to 5 lakh rupees. That's all about the power, duties, and liabilities of the directors. I hope you all have liked our podcast channel. If so, then do please subscribe our channel, The Noble Litigators. You can ask questions, give feedback, and for further queries, contact us on our website www.advocatetanwar.com. Thank you and have a good day.